Good afternoon, everybody, and welcome to Law 2022 Online, Criminal Law Shape the Debate. Apologies that we were a few minutes later than 1 o'clock starting. As one of my colleagues has put, we had some technical issues, but hopefully they're resolved now. So thank you very much for attending this live session. And you can put any of your questions that you would like to Colin and Clive. To the right-hand side, there's a chat function. All questions are submitted in private, so please ask away. And if you're watching on a replay, chat function is obviously disabled, but you may contact the solicitors group for further information. And a recording of today's session will be sent out via email over the next couple of days. So keep an eye out for that you can re-watch it. Okay, so I would like to introduce firstly our two experts for today, Colin and Clive. Colin Beaumont is a non-practicing barrister, a duty solicitor for many years and a consultant to a large criminal practice. Having formerly been a partner with the same firm, he has been advising on criminal law for 35 years. He has also been involved in teaching the profession for 30 years and has been professionally qualified for more than 37 years, having been called to the bar of the Inner Temple in 1982 and also in October of 2017. And part of Colin's Law 2022 Online sessions included youth court practice, procedure and criminal case law update. And then also we have Clive Smith. He spent 10 years at the bar practicing in London. Clive undertook almost exclusively defence work at all levels, from the magistrates and youth court to the Crown Court and the Court of Appeal. Clive's work spans a wide spectrum involving cases of armed robbery, kidnap, sexual offences and murder. And Clive's sessions included adverse inferences and silence and harassment and stalking. Okay, so to begin this session today, we will be starting with some pre-submitted questions. Okay, so Colin, the first one is for yourself. What does the defendant have to do in the case in order to be assured of 1/3 credit?
Yeah, okay, this is the important case, isn't it, of Placu, Borden and Smith. Can I just say welcome to you all. Called to the bar in 1982, so time moves on. It's 40 years now.
Oh, sorry.
I must update my biog. I know I don't look it, but there you are. Meanwhile, back at the question, Placu, Borden and Smith. Placu, of course, Plaku. Placu, Borden and Smith. The Court of Appeal said quite simply, in order to assure the client of 1/3 credit when he or she is sentenced, you must do one of two things. Firstly, if the offence is summary only or triable either way, you must enter your guilty plea at the first available opportunity. If the matter is purely indictable, whereby you can't plead in the magistrate's court, you must give an unequivocal indication of guilt, followed by a guilty plea at the PTPH hearing, the pressure to plead hearing. If you don't do one of those two things, your 1/3 is at risk. And then it's really a question for the lawyer at the Crown Court to seek to persuade the judge that perhaps it ought to be 1/3 rather than 25%, but the Court of Appeal won't interfere if they think the judge is correct in giving 25%. Clive, you might have a word or two about this. What do you say on it?
Yeah, not much more than you've said, really. As you say, it's got to be an unequivocal indication of a guilty plea. The other case, in fact, Placu is a good case to read, along with another case called Hodgin, because Placu effectively gives a digest. We had about 3 or 4 cases on this point, hadn't we, over the recent years, Colin? In fact, not over a series of months, really. Hodgin came out, and I thought, in fairness, Hodgin was going to be the last word in it. And then Placu came along. I thought, crikey, are people still not listening? So in a way, Placu makes things easy, because instead of reading the 3 or 4 cases that came previously, Placu acts as a digest of all those other authorities, which is really helpful. And Mr. Hodgin, I like the case of Hodgin, Colin, because the judge said in the Crown Court, he said to counsel, he said, He put on, the advocate had put on the form in the magistrate's court, likely to plead guilty, and the judge says likely to plead guilty means nothing and is well known to mean nothing. Now there's a criminal judge who's been round the block once or twice. He wasn't having any truck with what the advocate had put on the form. So yeah, I like the case of Mr. Hodgin. As I always remember Mr. Hodgin because he was hedging his bets, or at least his lawyer was anyway. So yes, absolutely. I have to say, and I know I've said this recently when discussing this with you previously, Colin, that some criminal practitioners and academics have said that actually the decision in Placu shows a disconnect between the Court of Appeal and practitioners. And I have to say, I have a great deal of sympathy for that view. I dare say it's been a long time since any Court of Appeal judge, particularly any of the Court of Appeal judges sitting in a case of Placu, were at your local magistrate's court, dealing with a long list of cases, dealing with Dwayne in the cells who's up for conspiracy to supply Class A, and there's 17 counts on the charge sheet, and you've got to go down to the cells. You're trying to fill out a legal aid form. Someone's banging on the wicket because they have not had a cup of tea today. You're trying to take instructions. Prosecutors got no authority to accept any pleas on the day. But apart from that, the Court of Appeal say, make sure you give an unequivocal plea in the magistrate's court, won't you, if you want your full third. So I have a great deal of sympathy for those who say that this shows a disconnect between the theory and reality. And equally, and you'll know this, Colin, from someone who's spent a lot of time around the magistrate's court, as did I for some time. Sometimes it's a judgment call for you as a lawyer. You might think, and I know you said this before, Colin, do you know what? I'm not going to indicate a guilty plea in the magistrate's court because I think when I get to the Crown Court, when these charges are actually set out on indictment, the charges, I'd rather take 25% credit of what's going to end up on the indictment than a third credit from what's currently on the charge sheet. And that's a judgment call for you as a lawyer. And I think, particularly if you're representing a client who's been round the block a few times too, if you explain that to them, and of course, it's always their decision whether to enter the plea or not. They can only ever, what you say to them is only ever advice, and they take it or leave it. Same way if your doctor tells you to give up smoking, you take or leave that advice. But I think there's plenty of clients out there who in certain circumstances would say, yeah, do you know what? I think I am going to take the chance. I'm going to chance my arm. I'd rather have 25% off the indictment than I would a third off what they're offering today. Thank you very much indeed.
And just to reassure Claire, all future answers will be much shorter than that.
No, that's fine.
Colin, I was surprised we had any time. We're going to be here
at 4 o'clock.
I was surprised we had any time when we finished reading out your CV, Colin. I thought, crikey, that's 2 o'clock, isn't it?
You know what they say?
I just made a note to update it to 40 years as well.
Yes. What do they say, Colin? Go on.
They say Colin Beaumont, a man with a brilliant future behind him. Carry on.
Okay, sorry. So the next question is for yourself, Clive. If a client gives a comment interview and misses out a particular detail, will the court still direct an inference drawn under Section 34?
Yeah, this is a good question. Is the court going to advise? So if you end up in the Crown Court, are they going to direct the jury to draw an inference from your silence or your failure to mention this in your interview? Or are you going to not quite get away with it? Is the judge going to say, well, take a view on it? And there are two possibilities here, really, aren't there? So in terms of not mentioning a particular detail, it might be your client simply didn't mention it in interview because they weren't asked about it, in which case I think you'd have a relatively strong argument to say, well, come on, judge, he wasn't asked about this. He gave his account at the start. He was asked particular questions. He answered everything that was asked of him. In terms of drawing inference, it's a bit harsh, isn't it? But equally, you may well have, and more likely to have, the pre-prepared statement situation, which of course is the well-known case of Knight, where your client, and indeed you as the lawyer, probably will have drafted that pre-prepared statement as well. And what the case of Knight says is that you're not expected to mention every last detail of your defence. In essence, what's required of you at the police station stage is to give the police an indication of what your defence is. So is it self-defence, for example? Do they need to worry about conducting an identification parade because you're running alibi? Or are you putting yourself at the scene and saying, yep, I did have a scrap with this chap in the pub. He knocked into me with his pint glass. We had an argument. He went to punch me and I ducked and I hit him first. Okay, that's why he's got injuries and I haven't. Or are you saying, alibi, I don't know what you're talking about. I was never there. I've been wrongly identified. And then they're going to have an identification parade. So in essence, at the police station stage, you're giving the police a steer about what your defence is. You're helping them narrow down the investigative lines that they need to be tracking down. So I think, in short, in answer to the question, probably not. At least you'd hope not. And I think in most circumstances, you'd probably have a good argument in front of the judge that they shouldn't draw an inference if your client has given a general flavour of their defence at that stage. Anything to add, Colin?
No, I'd agree with that.
Okay, brilliant, thank you. And then back to yourself, Colin. Are there any circumstances in which a Crown Court judge can make today's sentence consecutive to a period of Home Office recall?
The simple answer is no, but every so often, don't we get a case that has to go to the Court of Appeal because the judge has seemingly decided not to follow the provisions contained in the Criminal Justice Act 2003. It is the intention or the will of Parliament that today's sentence imposed by a Crown Court judge starts today, and it shouldn't be artificially inflated so that the defendant serves a period consecutive to the Home Office recall. A simple example of how it all goes a bit awry was the case in which the judge wanted to give a meaningful 6 months imprisonment on an offence of assault occasioning actual bodily harm. He knew the defendant had been recalled for a period of 9 months. And so he said, well, what do I have to impose today in order to ensure this defendant serves 6 months in addition to the 9 months recall that he's already going to have to serve? And the judge said, 9 plus 6 is 15. If I give him a 30-month sentence today, he'll have to serve 15 months, meaning he'll be serving 6 months after the 9-month period of recall. And the Court of Appeal said, well, yes, we can't fault the logic or the reasoning of that, but we're not having it because Parliament, as it were, has said in the Criminal Justice Act 2003, you can't do it. And so the sentence was reduced from 30 months to 12 months on the ABH. Of that 12 months, he would therefore serve 6. The 6 would fall within the 9, meaning he didn't serve an additional day. Just what the Crown Court judge was trying to avoid, but Parliament won't allow it.
Thank you for that. We've just had an additional question come in that says, I've noticed a lot more single convictions going on. There's an echo now, isn't there?
A small one.
Okay. Sorry, the person that submitted the questions has noticed a lot more single convictions going in, which seems to contradict the decision in Hanson. The latest was an assault going in that had no particular characteristics. Have things changed?
I think the short answer is no, and I absolutely understand where the author of the question is coming from, in the sense that Hanson, of course, says that a single conviction on its own is unlikely to go in to show propensity unless there is something more in the point you're making. So, for example, if it's a shoplifting and someone's got a previous for stealing alcohol from a supermarket and they're now charged with shoplifting and the allegation is that they stole alcohol from a supermarket, then that may well be admissible. So in terms of going in to show propensity, no, things haven't changed, but I suppose it always, classic lawyer's answer, isn't it? It depends why it's going in, doesn't it? So in terms of propensity, the short answer is no, nothing's changed. Hanson is still good law, and I would very much be referring your tribunal back to the decision in Hanson. But of course, it may well be that it's going in for different reasons, for example, to correct a false impression, or because somebody's made an attack on another person's character, those sorts of reasons, but certainly not in relation to propensity. No, the short answer is nothing's changed. Hanson is still good law. So it's a shame to see tribunals, seemingly in your experience at least, ignoring that decision.
Yes, I would agree with that. It really shouldn't be happening if it's going in to show propensity. As a Court of Appeal were at pains to say in the case of Hanson, one will rarely, if ever, show propensity. Why? It offends against the definition of the word propensity. One has a propensity to do something if one does it more than once.
Yeah. I think the author said, I'm currently appealing decisions of the Court of Appeals, so we shall see. We look forward to seeing the judgment in due course.
Yes, and they said, didn't they? It might go in, one might be sufficient if it bore sort of unusual hallmarks in the commission of the actual offence.
Yeah.
Okay, thank you very much for that.
Yes, thank you.
Back to yourself. If I waiver privilege to rebut an inference, must I call the solicitor to give evidence about what was said?
The short answer is no, but the danger is that the prosecution may well then comment on the fact that you've not called the solicitor. So going back to first principles, of course, it may well be, and I have to say this didn't happen in many trials I was involved in. It tended to be the more serious ones, the rapes, the murders, for example, where you would call your solicitor and your client would go no comment in interview, get into the witness box, of course, at trial and give an account. And the prosecution would understandably allege that they've recently made up this account to fit around the prosecution facts and witness evidence. And of course, the defendant might say in evidence, well, no, I haven't done this. I haven't made it up to fit around your story. And in fact, I told my solicitor this at the time. And of course, if they say, and I told my solicitor this at the time, then of course that potentially waive privilege. Now, in certain circumstances, you might, as the defence, want to say, and we're going to call the solicitor as well to come to court to give evidence, and give evidence about the conversation they had at the police station some 6, 9, 12, 18 months ago, however long it was, to say, look, I met him in the police station shortly after his arrest, and this is what he told me. So he's not just making it up now in the witness box. So, as I say, the short answer is no, you don't, because the question says, must I call the solicitor? And the answer is no, you don't have to. But if you don't, as I say, the danger is that the prosecution may well comment on it. And I don't think there's anything the judge would do to stop the prosecution commenting on that as well. So that the authority, which is set out in my slides and my notes this course, was the case of oral Seaton, which is the case you really need to bear in mind. So no, you don't have to call the solicitor, but you don't call the solicitor at your peril, really. I think if I was sitting on a jury, I'd be scratching my head saying, well, why aren't you calling the solicitor? And it may even be that you draft a Section 9 statement and serve that on the prosecution and see if they'll accept it and let you read it. They probably won't, but it's always worth a chance, isn't it?
Yes, I mean, I speak as a person who in a former life was a solicitor, and I was called to the Crown Court to explain to the judge by my client, called by the defence team to explain to the judge as to why my client had gone no comment.
Yeah.
Can I just add, you've mentioned the case of oral Seaton. Can I just add further in this particular area, another important case is Regina and Bowden. I would urge you to read Bowden, Bowden. And finally, I would urge you to read the case of Regina and Beckles, Beckles, Regina and Beckles, Court of Appeal 2004, and the very interesting comments from the then Lord Chief Justice, as he was, Lord Wolfe.
Yep.
Thank you.
Okay, thank you. And then back to you, Colin. Are text messages hearsay?
Are text messages hearsay? Well, this question troubles the Court of Appeal every so often, doesn't it? The latest one was Regina and Bedward. The one before that was Regina and Twist. And if you think about it, at first blush, yes, a text message would seemingly be hearsay. Why? Because the court is receiving this hearsay statement as a statement other than by way of live oral testimony coming from the mouth of a witness in the witness box, and would therefore appear to fall foul of Section 115 of the Criminal Justice Act 2003, of course, which is the definition of hearsay, Section 115, and defines hearsay as statements other than oral testimony. However, you must appreciate that in order for a statement to be a hearsay statement, it must be that the party seeking to reduce the statement in evidence must have as a purpose, or one of the purposes, for the truthfulness of that statement to be believed. In other words, if I'm putting it in as a prosecutor, it only becomes a hearsay statement if I want the court, as it were, to accept it as being the truthfulness of that which was put in the text message, which, if I were prosecuting, more often than not, would not be the reason why I want these text messages in. More often than not, I'd want them in a joint enterprise case or a conspiracy, simply to show that people were communicating with each other. Nothing to do with the truthfulness or otherwise of the contents of their communications. And so long as you appreciate that, you will appreciate that most of the time, hearsay text messages are not hearsay.
Just to add to that, Colin, the case of Midmore is always a good read as well. And it also deals with the issue of common enterprise, which is, of course, is one of the exceptions to the hearsay rule under Section 118 of the Criminal Justice Act 2003. And Midmore is a classic example of it depends who you say what to. So you said in certain circumstances, of course, the prosecution might just want a text messaging to show contact, that two people know each other in a conspiracy. Equally, you might send it to one person just for their information. You might send a text message to another person, causing them to believe it was true. So it will depend not only on what you say, but who you say it to as well.
Okay, we've just had another question come through. Is it good practice to sentence a defendant in their absence? They've had a few of these lately. Sentence only starts once the defendant produced to court. If defendant serving prisoner, then any way to sentence without his production at court?
Claire, can I pose a question? And if the poser of this question would answer it, please. Which court are you in? Are you in the Magistrates' Court or are you in the Crown Court? Could you just put that into the chat, please? Because it will greatly assist in the answer.
We can deal with both if you want to, though, Colin.
We can deal with both, but I have a feeling from the way the question is worded that it's a Magistrates' Court question. But I just like confirmation of that.
Magistrates,
yeah.
Okay, well, your starting point will be Section 54 of the Criminal Justice and Immigration Act 2008, which for the first time ever really introduced the concept of magistrates sentencing in absence after perhaps having convicted after a trial. You've got to be careful, though, because the criminal procedure rules say that magistrates shouldn't really sentence in absence by way of custody unless the case proceeded by way of having been charged and bailed to court. If proceedings commence by means of an information and a summons being issued, or a written charge and a requisition, then sentence by way of custody in absence ought not to take place. So please do be aware of Rule 24 of the Criminal Procedure Rules 2020 as amended. Rule 24, trials and sentencing in a magistrate's court. Now, if I were to wear the hat of a legal advisor for a moment, I might turn to the magistrate and say, look, yes, you've convicted after a trial. The trial has been held in the absence of the defendant. The proceedings commenced by way of charge and he was bailed to attend the court. You therefore can proceed to sentence in absence by way of custody today if you wish to. And of course, if you do sentence to custody in absence, then of course the warrant will say to the officer, you are to arrest this person and you are to bring this person back to the magistrate's court. And that appearance in the magistrate's court is deemed to be the first day of the custodial period. Of course, it's also a classic day for the duty solicitor, perhaps, or another solicitor to argue that perhaps there shouldn't have been a conviction in absence and a custodial sentence in absence. And then it's really a question for the lawyer to argue as to whether or not the magistrates are going to undo that which their colleagues did previously. They may say, no, we have both convicted in absence, we have sentenced in absence. You now have your rights of appeal to the Crown Court. If you're unhappy with both the conviction and the sentence, see the Magistrates Courts Act 1980, Section 108. Had I been the legal advisor, I think I'd have been saying to the magistrates, well, rather than sentencing to custody in absence today on the occasion of the conviction, why don't you consider issuing a warrant, not back for bail, to get him before the court when he can be sentenced next time? But there would be nothing unlawful in what the magistrates or district judge had done, assuming under the criminal procedure rules, the proceedings had commenced by way of charge and bail to court.
Can I say this as well as a practical point, Colin? If I was a lay bench and I'd convicted him in his absence, the chances of me sitting the next day, the next week, the next month when he's arrested on his warrant and brought before the courts for sentencing are slim to none. And it might be said that the court who tried him and heard the evidence in his absence is best placed to sentence him. And it may well be the same. I know we're going to move on to the Crown Court in a moment too. If I was sitting in the Crown Court as a recorder, I might think, well, because the only other thing that recorder might do, but it always causes problems, is to say, well, I'm going to issue a warrant and I'm going to reserve sentence to myself, which means then finding a date when he or she, whoever it is arrested, brought back before the court, remanded in custody. There's a date found for the judge's convenience to come back and sentence him. It all becomes a bit of a palaver, to put it mildly. Whereas if I'm a district judge or I'm a permanent judge sitting at the Crown Court and I think, well, whenever he's picked up, he can just come back before me. Or if I'm away that week, they can just put the case back for a week because he's going inside anyway for a bit of failure to surrender. So he may as well start serving already, hadn't he? So he can come back in front of me as and when I'm sitting next, and I'll reserve it to myself. So you've given the legal advisor's perspective, which is absolutely valid, but I just wanted to give a perspective that might be going through the tribunal's mind as well in terms of what you're up against.
The question also says, if the defendant is a serving prisoner, then any way to sentence without his production at court? Yes, if the serving prisoner refuses to leave the cell and refuses to come to court, I would have thought so long as he's represented by a lawyer who simply says to the court, my client refuses to attend this court for sentence, I would have thought the legal advisor is going to advise the magistrates, or the district judge for that matter, to get on with it and sentence.
I think exactly this happened at the Old Bailey recently, Colin, with the murder of the MP, Sir David Amos. His killer, having been convicted, refused to attend court, and of course the Home Secretary said that the government were considering powers to bring people to court. Well, all I can say is, let's get the Home Secretary and the Lord Chancellor to go and get these people from prison and take them to court, because all it's going to end up in is a lot of pain and misery for the jailers and the staff who have to actually get them to court. I can tell you now, they will be kicking off big time when they go into their cell to try and get them out of there.
Of course, the rationale behind Rule 24, this business of he should have been charged and bailed to attend court, is that he must be aware of the actual court appearance. That's the rationale behind it. You can never be sure, that a person knows of the court appearance if the proceedings have commenced by way of a requisition or commenced by way of some sort of summons or single justice procedure. These things are all sent out in the post. Not so with a person who's charged and bailed to court. We know that he might not know an awful lot, but he knows about the court date. Right, so, of course, if your client refuses to leave the cell, the mischief isn't there. He knows about today's appearance. Sorry, Claire.
It's all right. No, you go for it. And then we've just had another question come in. Can you still move on to the Crown Court part of this question too, please? Answering live questions is always priority.
Gosh, I would have thought, Clive, I don't know what you say, but Surely you're not going to be at the Crown Court and not know of your appearance. And
No.
once you've cast aside that particular mischief, of course the judge can get on with it and sentence in absence if he or she wants to.
Of course, we had the case of Umajai recently, didn't we, Colin, about people being sent in their absence to the Crown Court, but as long as they're legally represented.
Yes.
So,
I mean, we've got that case of Gillette, haven't we? Regina and Gillette, the best a man can get. Gillette is authority for the proposition, you know, that you really shouldn't be sending people to custody who have never been to custody without exploring non-custodial options in a pre-sentence report. So if I were the advocate appearing before the judge, I would certainly pray that case in aid. Judge, he's never been inside before. If you're thinking of custody today, might it not be more appropriate to issue a warrant? It might be the report should be prepared whereby options other than custody can be considered. Of course, the judge might come back and quote at me the case of Arasama. Arasama is authority for the proposition that if the judge takes the view that the ordering of a pre-sentence report is merely a box-ticking exercise and that it has to be custody, then custody in absence today.
And that's exactly what happened to me at Maidstone, Colin, where I had a trial in absence of robbery. My client, I don't think he had a couple of previous, but had never been to prison before, was convicted of robbery in his absence. And it was completely futile for me to make that submission because on the guidelines at the time, conviction after trial, even for first offence, starting point, 4 years imprisonment. So, of course, we were double the amount of time the judge could have suspended. I think at the time you could only suspend 12 months anyway. So we'd well and truly breached the custody threshold. So yes, such an application would have been academic. Of course, one thing that needs to happen and should happen in these circumstances is that the defendant needs to be brought to court before being taken to prison to start serving their sentence, because of course the court will want to put to them the failure to surrender charge, and it may well be they get 14 days or 28 days on top, depending how long, of course, they've been at large. If they've been on the Costa del Sol for the last 5 years, then there might be a problem. I very much remember being in London when two gentlemen were arrested for a robbery, a street robbery in London, about 3 years after the event. They turned up to their PCMH, I think, and then failed to surrender for trial. The trial hadn't proceeded in their absence, but the Crown didn't know whether or not they could proceed because the person they'd allegedly robbed was now back in Spain. They'd been on holiday when they'd been robbed, and so I'm not sure they had any contact details for them. So so the judge remanded them in custody anyway, whilst the Crown made inquiries. So they had to serve a little bit of time for their failure to surrender over 3 years. But yes, there we are. Practical considerations will often come into play in all of this, won't they, Colin, as much as legal considerations?
They will. And here's another one-liner for you from the case of Arasama. And the judge said, of course, if I were to order a report today, what more would it tell me? Gosh, I've learned so much from counsel in his eloquent submissions.
Yeah, flattery, eh, Colin? Flattery.
Oh, there you are. The better your counsel, the more likely you are to go to clink in absence. Okay, Claire, over to you.
That's okay, brilliant. Thank you very much. So the next question, back to yourself, Clive, is under section 35, an inference won't be drawn if it is undesirable for the defendant to give evidence. When would it be considered undesirable?
Clive, could you just clarify section 35 of the Act?
Criminal Justice and Public Order Act, I think, in terms of inferences and failure to give evidence at trial.
Yeah.
This is a really good question. And I think if you were to be asked this question 10 years or so ago, the answer might be slightly different. The short answer to this question is, I think the circumstances in which it will be considered undesirable for defendants to give evidence are becoming vanishingly small. As I say, if we were to go back 10 years ago, we're now in a situation, in fact, Colin and I were discussing this just before we came on air, about vulnerable witness training, and that most of you now should have undertaken, if you're dealing with these sorts of cases, your vulnerable witness training in terms of cross-examination of vulnerable witnesses. But of course, the same applies to prosecutors and the CPS in terms of cross-examining vulnerable defendants. We're now at a stage, of course, when the Act was passed back in 1994, we didn't have such things as intermediaries. We didn't have such things as vulnerable witness training. And so I think there are far more tools in the court's toolbox in terms of being able to facilitate defendants being able to give evidence. So the leading authority I think I referred to in the notes was the case of Friend, where the defendant in that case had an IQ of 63. I remember representing a defendant who had an IQ of 49 as well. And in those circumstances in the magistrate's court, it was held undesirable for him to give evidence. They didn't draw an inference and they still convicted him, which was against the strength of the evidence, I felt, but there we are. But as I say, I think the circumstances in which it will be undesirable, because it doesn't feel like a very strong test, does it, Colin? Undesirable. That doesn't feel like a hugely insurmountable threshold. Notwithstanding that, though, I think it's becoming increasingly difficult. It's going to be, and I'm really thinking back to my very early days in my career, I represented a defendant who was actually found unfit to plead. And it's going to be those defendants who are right on the borderline, I think, of being fit to plead, where an expert says, by a whisker, I think they are fit to plead. However, I do not think they are fit to give evidence, even with the assistance of an intermediary and even with skilled advocates undertaking cross-examination through pre-planned questions as well. So, as I say, I think it's going to be vanishingly small, those circumstances. It's already relatively unusual for the judge to say that. But as I say, I think over the last 10 years or so, with intermediaries, the advocates gateway, with the toolkits that we use now, with the pre-submitted cross-examination questions, all those things, the circumstances in which they don't give evidence, I think, are likely to be confined to those cases where the experts say, by a whisker, I find them fit to plead.
And isn't there something within Section 35 about unfitness, unwellness? Pretty sure there is, in Section 35, unwell to give evidence. It might be that he's unwell. Okay, he's attended his trial, but the judge concedes that he's actually unwell to give evidence.
There was the case, wasn't there, Colin, a couple of years ago at Norwich Crown Court, where I think the defendant was epileptic, wasn't it? And he was suffering from fits during the course of the trial.
Yes.
And the judge said, it's fine, I'll just tell the jury not to draw an inference. Yes. And the Court of Appeal said, no. They said it's not just the not drawing an inference, it's the not providing him with the opportunity to give evidence should he be able to. And that's effectively what the judge had denied him the right to do, hadn't he, in those circumstances?
Yeah. And that was the judge effectively using Section 35, as it were.
Yeah. To say, I'm not going to direct an inference, but the defence was saying, no, we don't want that. We want him to be fit enough to give evidence. It was quite a serious case, wasn't it? It was either a Section 18 or a death by dangerous or something like that.
Yeah, I think both counsel approached the judge and said, look, we really shouldn't be carrying on, Judge.
Yeah, and he said no. But yeah, so there we are. There's an example, Colin.
Hello, Claire.
Hello, okay. So moving on to the next question, Colin, in what circumstances may a defendant be sent from the magistrate's court to the Crown Court in their absence?
Yes, we didn't really think it was possible. Clive's already mentioned the case of Umerji, Umerji, in which the Court of Appeal said that, we don't think that the earlier case of Taylor has been rightly decided, and we don't really like the comments that were made in the Janner case as well, Janner. And they said if the matter's purely indictable and the defendant is represented by a lawyer at the magistrate's court stage, see no reason why he couldn't be sent in his absence. Section 51 of the Crime and Disorder Act 1998. They said it couldn't be done if the matter were either way, because of course the client has to be there in order to deal with such matters as to whether or not he's going to enter a plea, whether or not he's happy for the trial to be in the magistrate's court if the magistrates accept jurisdiction. Of course, we have Court of Appeal authority, don't we, that says that a lawyer cannot enter a plea to an offence that's triable either way on behalf of a client. That plea can only be entered by the client himself, herself. Different, of course, if the proceedings are summary, where lawyers can enter pleas on their client's behalf. Claire.
Yep. Okay, great. Thank you. And Clive, when a client changes his account at trial from that which he said in interview, should the court give both an adverse inference direction and a lies direction?
Can I say, Clive, this is a great question, and I don't know the answer.
Ooh, well, here we are, Colin. A voyage of discovery for you. As a
Indeed.
general rule, the Court of Appeal said back in 2011, now in the case of Hackett, that as a general rule, the court should not give both. Because in reality, you're giving a double direction about the same thing. It's almost, to use a sentencing phrase, double counting, isn't it? The defendant has done one thing wrong in the sense that he has either lied in his interview in the sense of saying, I wasn't there, and then at trial he said, actually I was there and I was acting in self-defense. Or there's an adverse inference, of course, because he didn't mention in his interview that he was there and he was acting in self-defense. So in terms of trying to have both, the Crown are effectively seeking to have their cake and eat it, I would suggest. So the case of Hackett suggests that as a general rule, you should not give both directions. Now, we've had a more recent authority on this, the case called Wainwright from 2021. And in the case of Wainwright, it said that in certain circumstances, in some cases, it may be appropriate to give both an adverse inference direction and a Lucas direction in relation to lies as well. I think the suggestion in Wainwright is that in longer running cases where there might have been more that the defendant could have said in his interview, for example, that he's obviously not mentioned or he's lied about, then it would be more suitable in those circumstances. But I say Hackett as the starting point effectively says to the Crown, these are my words, not the Court of Appeals, but the Crown should be put to their election. Which do you want? Do you want the adverse inference or do you want the lies? Right. And let me say this to you, that judges do not like giving adverse inference directions. Reason being is they are long and verbose. And so if judges won't tell you that, well, they won't tell you in open court anyway, but they'll tell you privately. They never like giving them because they're long. So if I was defense counsel, I would always be suggesting that they might want to give the lies direction rather than the adverse inference direction, but entirely a matter for you. But say in certain circumstances, it might be appropriate, said the Court of Appeal in Wainwright, to give both directions. But back in 2011, in the case of Hackett, the Court of Appeal said, in straightforward, relatively simple cases, the prosecution should choose. It needs to be one or the other. You can't have both.
Well, that's a very logical and sensible way of dealing with it. Thank you for that. I mean, I genuinely didn't know that. And as an advocate, I'd rather have a Lucas anyway, because a Lucas might be might rather be beneficial, whereas an adverse is always going to be adverse by definition.
Exactly. Yes. Yeah. But no, I have to say that Hackett is a great case as an advocate to have up your sleeve. I think every time, I don't say this lightly, but every time I doled that case out when we were discussing summing up, I used to, 9 times out of 10, I would win the argument on that point. And most times the prosecutors would read the case and say, Mr. Smith's right, actually, I do need to choose which one. Yeah, really, really good case to have.
Could you at some point, Clive, in an email, could you pop over the citations for both of those for me?
Yeah, of course I can.
I'm so glad I came today.
There you are.
I'm not waving my fee, Claire. I'm not waving my fee. I'm just saying I'm so glad I came today. Don't you go telling tales back at the office. Carry on.
Yeah. Okay then. So Colin, it's back to yourself. Is it possible for a child or young person to be sent from the youth court to the Crown Court?
Okay, well, let's define the term, shall we? As in today, we have naming of parts. Children are aged 10 to 13. Young people are aged 14 to 17. Adults are aged 18 or over. Now, it is possible to send from the youth court to the Crown Court, but it would be a very rare occurrence. Your sending provisions are sections 16 and 17 of the Sentencing Code or Sentencing Act 2020. There are certain instances in which a child or young person must be sent from the youth court to the Crown Court. Why? Well, because the court is dealing with a case that it can't entertain jurisdiction on. For example, it might be murder. Case must be sent. Can't take a plea on a murder. It might be manslaughter. Case must be sent. You can't take a plea on a manslaughter. It might be that the person is 16 or 17 and it's a firearms case, in which case, of course, the court is obliged to consider the imposition of a mandatory minimum sentence of at least 3 years. And because of that, you can't take a plea. The matter must be sent. So do please bear in mind there are certain instances in which, as a matter of law, that child or young person must be sent from the youth court to the Crown Court because no plea can be taken. But in circumstances where a plea can be taken, and let's face it, that's the vast majority of cases that appear before the youth court, because the youth court can take a plea to indictable only offences like robbery, like grievous bodily harm with intent, like rape. In most of those instances, a plea will be taken. And if it's a guilty plea, well, of course, the client might find himself or herself committed for sentence from the youth court to the Crown Court. Or it might be a not guilty plea, in which case there's going to be a trial, and thereafter there might be a committal for sentence from the youth court to the Crown Court. These committals for sentence sections, of course, sections 16 and 17 of the Sentencing Act 2020, not to be confused with your sending section, which is section 51 of the Crime and Disorder Act 1998. But it might be, on occasion, there's a youth, might be 16, might be 17, appears before the youth court charged with a number of knife point robberies, charged with a really serious grievous bodily harm, which is tantamount to attempted murder, charged with a really serious rape. And the judge says, district judge says, I'm not taking a plea. I am not taking a plea. I will send this case to the Crown Court, section 51. Next case, please, because this one has just finished. Thank you, Claire.
Thank you very much. We've just had another live question come in about drug driving cases regarding handling of blood samples and testing of them. They understand a sample should be offered to the suspect. The police keep the blood in their fridge and there could be danger of contamination.
The sample should be offered to the suspect. Please keep blood in their fridge. Well, what can I say? With the greatest of respect, that's not really a legal question, is it? That's a question upon which you're going to need the assistance of some sort of expert who is willing to form the opinion that based upon how procedurally things happened, there may or may not have been contamination. That's not a lawyer's question. Clive, I don't know if you have anything to add to that.
No, absolutely. You'd need expert evidence in terms of contamination. As I say, it's going to have to be more than merely speculation, isn't it, as to how the contamination has taken place. You're going to need some sort of evidence about that. Just because they keep blood in their fridge, you would have thought they keep them securely. To the extent that even if they are in the same fridge as somebody else's blood, then it doesn't necessarily mean that the two are going to be contaminated by one another. So, as you say, firstly, you're going to need some evidence to get off the ground in terms of the suggestion that it has some sort of contamination has taken place. And secondly, you're going to need some sort of expert to comment on what the consequences of that would be.
I mean, it's always been the case. It's always been the case. I mean, leaving aside drug driving, it's always been the case that in drink driving, we've had that for many, many, many years, haven't we? When a sample of blood is taken, of course, half of that particular sample is given to the suspect. They are a suspect at the time, and the other half is sent off for analysis. One would say that exactly the same considerations apply with drink driving, where a blood sample has been taken, as apply to drug driving. But I think, you've got evidentially you've got quite a mountain to climb to show that the procedures as they were adopted were so irregular that there is this possibility of contamination, of course, and only an expert could give a view vis-a-vis contamination. But I can't help feeling that how can I put this? It's probably not your strongest argument.
Of course, the other point is, Colin, you're given a sample. Send it off for your own examination. That's the whole purpose of being given your own portion of the sample, to send it off for your own examination. I think the court would look dimly on a case where you are criticising the prosecution's evidence but not advancing any of your own, unless there are good reasons as to why you weren't able to send your own sample off for its own analysis.
I mean, I don't know whether or not these people are given literature at the time when they're given their half of the sample, as in, this is what you should consider doing with your sample. Firstly, store it in a cold place, blah, blah, blah. I've never actually seen any literature that's been given, but I suspect it is given.
Yeah.
Okay, thank you very much for that. So, Clive, in summary proceedings, it's been mentioned that evidence from outside the 6 month time limit will potentially be admissible in harassment cases. What about in common assault cases? Would this be the same?
Clive, could I just say something at the very beginning? Is it true then that evidence from outside the 6 month time limit will be potentially admissible in harassment? Can we just clarify that point?
Yes, it is, as long as one of the incidents took place within the 6 month time period, because of course, in order to constitute harassment, it has to be on more than one occasion. So as long as on one of the occasions out of the two happened within the 6, as long as you've got your foot in the door of the 6 months, one of the other incidents can take place outside the 6 months. Absolutely, no problem with that. And the case law is in the notes and the slides, Colin.
Yes, I agree with that. Yeah.
So this is a good point, and indeed a really important point at the moment, because as you know, Colin, and some of you out there will know, the Police Crime Sentencing and Courts Act of 2022 has just amended, although not in force yet, but has amended for the future the time limits for charging in domestic abuse cases. So the question here is about common assault. But where a common assault takes place in the context of domestic abuse, which is defined under Section 49 of the Police Crime Sentencing and Courts Act, then the time limit for charging has been increased to 24 months, so 2 years. So no longer 6 months, it's 2 years. So in answer to the question, what about in common assault cases? Of course, in order to be guilty of common assault, it only needs to happen on one occasion, and therefore you'd need to have it. It would, if you're charging the one common assault in particular, that would have to take place within the time limit. But as I say, the time limit will be changed at some point in the future to 24 months. It may be you're charging a common assault, and it might be. Let's proffer this scenario. Complainant comes forward for the first time to the police. She says, "My boyfriend last week hit me, and he's been doing this for the last 3 years as well." And it might be, of course, that you've then got a common assault which took place 9 months ago, 12 months ago, and 18 months ago. Now, of course, you're not going to be able to charge the 9 months, the 12 months, and the 16 months ago one, or the 18 months ago one, because you're outside the time limits. But it might be that you charge the one, and it might be, as a prosecution advocate, you try and get in those other incidents as evidence of bad character. 2 cases you should be aware of. I'm not going to dwell on either of them. Firstly, the case of Braithwaite, which is a case from 2010 in relation to previous unproven allegations. And the other case is the Supreme Court's decision in the case of, what's the one about propensity, Colin? The lady in Northern Ireland.
Mitchell,
that's the one. The case of Mitchell on propensity and what needs to be proved where more than one previous allegation is mentioned. So I'm not going to dwell on either of those, but both a good read. Firstly, the case of Braithwaite. Secondly, the case of Mitchell. And as I say, Section 49 of the Police Crime Sentencing and Courts Act.
Can I put a gloss on your 2-year period? Because the
Go for it.
legislation actually says, of course, that such proceedings could not be charged outside of 2 years, but they can be charged within 6 months of her making a statement admissible in criminal proceedings. So she makes her statement admissible in criminal proceedings 19 months after the event. Can they charge? Yes, because they fall within the 2-year period.
Yep.
Thank you. Okay, this is probably going to be our last question now. So Colin, in what circumstances might a child or young person be committed for sentence from the youth court to the Crown Court?
Okay, so now we're in the realm of committals for sentence rather than sendings. Please, please, please be careful with your terminology. In terms of children or young people being committed for sentence from the youth court to the Crown Court, one must look at sections 16 and 17 of the Sentencing Act 2020. Section 16 permits the youth court to commit for sentence, but it's not like the ordinary adult committal for sentence. You know, don't you, that adults can be committed for sentence under section 14 with any offence that's triable either way. Not so with children or young people. If you look at section 16, they can only be committed for sentence if it's a serious offence. Those offences we used to formally refer to as grave crimes. They are now mentioned in section 249 of the Sentencing Act, and there's a committal for sentence of this serious offence in order that the judge could consider sentencing under section 250, detention under section 250, this being a serious offence. It's going to be something like a rape or a robbery or a grievous bodily harm with intent, where the youth court have taken the view that it warrants something more than a 2-year detention and training order. It's going to be a rare occurrence, is a committal under section 16. Under section 17, an even rarer occurrence, the committal for sentence of a child or young person under the dangerous offender provisions. That, being quite frank, is just never going to happen.
Okay, thank you very much for that. That was our last question. So unfortunately, that is all that we've got time for today. So thank you very much for taking part and watching Law 2022 Online, Criminal Law Shape the Debate. And I'd like to thank our expert speakers, Colin and Clive, for attending today and answering all the questions. And don't forget that the feedback form for this event is available in the related link section on the website of your account. By completing this, you will receive your CPD certificate via email. And also, please don't forget to visit the online exhibition at www.thesolicitorsgroup.co.uk. By visiting the exhibition, you can access a free 1-hour CPD webinar from our webinar learning category worth £35. So that's all we've got time for today then. So just I'd like to say thank you very much again and have a great day.
Claire, can I just add a rider, if I may? And I may
course,
be, I hope I'm not doing anything wrong by saying this, but if there were any people out there who still had questions, which we didn't have time for, is there any possibility they could send them to the solicitors group and then you could forward them to myself and Clive?
Yes, you can do. So if anyone does have any extra questions, if you email it to enquiries@thesolicitorsgroup.com, so that's the email address, and then what we'll be able to do is obviously communicate with yourself and Clive, and then get any responses back to
excellent
attendees.
I mean, so long as you appreciate, we can't give you legal advice, but we can certainly point you in the direction of case law and statutes. Yeah, that's brilliant. Thank you very much. Thank you, Claire. Thank you, Clive. Thank you, everyone out there. Have a good day. Take care. Bye.
Yes. Bye-bye.